in God's created world. On one occasion, the good Lord said, "Everything is going to be all right." On another, "You will see for yourself that every sort of thing will be all right." In these two sayings, the soul discerns various meanings. One is that he wants us to know that not only does he care for great and noble things, but equally for little and small, lowly and simple things as well. This is his meaning. Everything will be all right. We are to know that the least thing will not be forgotten. Another is this. We see deeds done that are so evil and injuries inflicted that are so great that it seems to be quite impossible that any good can come of them. As we consider these sorrowfully and mournfully, we cannot relax in the blessed contemplation of God as we ought. This is caused by the fact that our reason is now so blind, base, and ignorant that we are unable to know the supreme and marvelous wisdom, might, and goodness that belong to the Blessed Trinity. This is the meaning of the words, "You will see for yourself that every sort of thing will be all right." It is as if God were saying, be careful now to believe and trust, and in the end, you will see it all in its fullness and joy. Amen.
Amen. The Secretary will now call the roll of senators.
The Honorable Senator Judges Angara, Arroyo, Cayetano Alan Peter Compañero, Cayetano Pia, Defensor Santiago, Drilon, Ejercito Estrada, Escudero, Gingona, Honasan, Lacson, Lapid, Legarda, Marcos, Osmeña, Pangilinan, Pimentel, Rector, Revilla, Soto, Trillanes, Villar, the Senate President.
With 19 senator judges present, the presiding officer declares the presence of a quorum. Majority Floor Leader.
Mr. President, may I ask the Sergeant-at-Arms to make the proclamation?
The Sergeant-at-Arms is directed to make the proclamation.
All persons are commanded to keep silent under pain of penalty while the Senate is sitting in trial on the articles of impeachment against Chief Justice Renato C. Corona.
Majority Floor Leader.
Mr. President, I move that we dispense with the reading of the February 29, 2012 Journal of the Senate sitting as an impeachment court and consider the same as approved.
Is there any objection? There being none, the February 29, 2012 Journal of the Senate sitting as an impeachment court is hereby approved.
Appearances, Mr. President.
The Secretary may now call the case.
Case number 002-2011 in the matter of impeachment trial of Honorable Chief Justice Renato C. Corona.
Appearances, Majority Floor Leader.
Good afternoon, Your Honors.
Prosecution.
Good afternoon, Your Honors. The prosecution is ready. Same appearance, Your Honor. We're ready till 7 o'clock, as agreed, Your Honor. Thank you.
As noted.
For the defense, Mr. President.
For the defense, Your Honor, the same appearance. We are ready, Your Honor.
Noted. Majority Floor Leader.
Mr. President, Counsel for Chief Justice Corona filed a motion to suppress illegally obtained evidence, seeking to expunge from the record all evidence offered, received, and proposed in relation to the subpoenas addressed to PS Bank Branch Manager Ms. Annabel Johnson. For its part, the prosecution entered its opposition thereto. The impeachment court issued on March 6 its ruling on the motion, and the parties have been notified of the ruling of the court, Mr. President.
The motion to suppress illegally obtained evidence dated February 22, 2012 is hereby denied for lack of merit. The clerk of court is directed to include the entire resolution in the record of the impeachment court.
Thank you, Mr. President. Just for the record, as requested by Senator Pimentel, this motion was voted on unanimously by the members of the court.
Majority Floor Leader.
Mr. President, also as directed by the court, the House panel of prosecutors filed on March 2, 2012, their formal offer of documentary evidence, while the counsels for respondent, Chief Justice Corona, also as directed by the court, submitted their comments, objections thereto on March 7, 2012. The impeachment court has ruled and made this representation read the dispositive portion of the ruling of the court.
Proceed. Please read the dispositive portion of the ruling of the court.
In view of all the foregoing, acting on the formal offer of documentary evidence of the prosecution and the comment objections of the defense thereto, the court resolves to admit Exhibits A to 7Os and Exhibits 7Qs to 10Ns of the prosecution, subject to the appreciation of the individual senator judges as to their weight and sufficiency for the purposes for which they have been offered. Further, the foregoing documentary exhibits are admitted as part of the testimonies of the witnesses who testified thereon. The tender of excluded evidence consisting of Exhibits 7Ps to 7Ps-7 is hereby disallowed for being improper, as these documents have already been excluded by the court because they tend to prove bribery, a crime not alleged in Article 3 of the Articles of Impeachment. The tender of excluded evidence serves no purpose because there is no appeal from the decision of this court. The prosecution is deemed to have rested its case, subject to its reservation on the presentation of evidence on the dollar account of Chief Justice Renato Corona, should the Supreme Court rule that the presentation of evidence of such bank accounts before this court will not violate the provisions of Republic Act 6426. The initial reception of evidence for the defense is set on March 12, 2012 at 2 o'clock in the afternoon. So ordered, March 12, 2012, Pasay Chief.
Your Honor.
Mr. President.
Majority Floor Leader.
Your Honor, please. Your Honor, please.
Mr. President, the prosecution wishes to be recognized.
Your Honor, please. May we just reiterate, Your Honor, that with the admission of our documentary exhibits as well as the testimonial evidence of our witnesses, Your Honor, the prosecution is resting its case subject to the reservation we have earlier made pertaining to the dollar account of the Chief Justice.
Yeah, well,
Thank you.
just wait for the written resolution of this particular matter by the court, and you may make a comment or assert your reservation after you have read it.
Thank you, Your Honor.
Okay. Majority Floor Leader.
Yes, Mr. President, in compliance with the directive given by the presiding officer, the prosecution filed a notice manifestation confirming their oral manifestation that they have terminated the presentation of evidence on Articles 2, 3, and 7 of the Articles of Impeachment, and that they will no longer present evidence on Articles 1, 4, 5, 6, and 7. The prosecution submits that the impeachment court need not vote upon the charges in the above-mentioned articles. On March 8, counsel for Chief Justice Corona filed a motion to dismiss, seeking to dismiss the charges against the Chief Justice under the same articles with prejudice in view of the prosecution's failure to prosecute and present evidence in relation thereto. I move that the presiding officer rule on the motion.
Thank you. Regarding the motion of the defense to formally dismiss Articles 1, 4, 5, 6,
And 8.
and 8
Yes.
of the Articles of Impeachment, the impeachment court in a caucus decided not to act and not to entertain and act on the motion to dismiss. with the clear understanding, however, that no evidence from both prosecution and defense panels will be received by the impeachment court on Articles 1, 4, 5, 6, and 8, and furthermore, that the members of the impeachment court will not render any vote on Article 1, 4, 5, 6, and 8, and that no verdict of the impeachment court will be rendered on Articles 1, 4, 5, 6, and 8. So ordered. Majority Floor Leader.
Mr. President, the prosecution also confirmed their oral manifestation that they are reserving and not waiving their right to present evidence pertaining to dollar accounts of the respondent in connection with Article 2. On March 7, Counsel for Chief Justice Corona filed its opposition thereto, praying that the impeachment court deny the reservation to present additional evidence on alleged dollar accounts. I move that the presiding officer rule on the motion, Mr. President.
This matter has already been ruled upon previously by this court when we ruled on the suppression of the evidence involved. But nonetheless, I would like that the both panels will read the ruling of the court with respect to the admission of the offered evidence by the prosecution, as well as its ruling on the objections or comments filed by the defense on that offer of evidence. So ordered. Majority Floor Leader.
Yes, we are in receipt of a request for issuance subpoena ad testificandum et duces tecum to the Secretary General of the House of Representatives, several representatives, and the executive producer program manager of the news program Head Start of ABS-CBN News, or the official custodian of its news videos, to appear for examination before the impeachment court so as to their knowledge or personal knowledge regarding the verification of the verified impeachment complaint. I move that the presiding officer rule on the motion.
This is in connection with the ABS-CBN.
And also the subpoena for the House of Representatives and other representatives on the verification of the verified impeachment complaint, Mr. President.
Since the purpose of the subpoena is to present evidence on the circumstances on the verification of the articles of impeachment, which has been previously ruled upon by this court when it considered the motion for preliminary hearing filed by the defense, the request is hereby denied. Now, with respect to what else has been... Majority Floor Leader.
Yes, well, all of the requests are denied, Mr. President, for the record, including the request for the ABS-CBN custodian. So, finally, Mr. President, on March 9, the prosecution filed its motion requesting that the defense panel be directed to manifest the order of its presentation of evidence in order to afford the prosecutors the opportunity to prepare for the reception of evidence of the defense. I move that